We are live.
Great. Welcome back, everyone, to the House Healthcare Committee. This afternoon, we're taking up S47, an act relating to the transport of individuals requiring psychiatric care. So we have Legislative Council walk through the bill, and then we'll start with our testimony. So I'm turning it over to Katie.
Perfect. Good afternoon. Katie McLean, Office of Legislative Council. Before I pull up the bill, I thought maybe I would just step back and give you a little overview. I suspect, depending on what you take up, maybe I'll be back for a larger overview, but I'll kind of give you a little narrow piece to chew on while we're looking at this bill. So this bill deals with transporting individuals who are not yet in the care and custody of the Commissioner of Mental Health. It talks about one of the avenues that a person might become in the care and custody of the Commissioner of Mental Health. So there in statute, there is language, a process called the emergency exam, and it's a two-step process. And the emergency exam is the process by which it's determined if a person should potentially be hospitalized in the care and custody of the Commissioner of Mental Health. The first prong of that two-step process is bifurcated depending on if there is a physician available. So if there is a physician available to do an examination, then that's called the first cert or the initial cert. It's the initial exam. If there isn't a physician available, but maybe a mental health worker or police officer or whoever is observing the individual and seeing that this person is likely a person in need of treatment, they could get what's called a warrant, not the kind of warrant you're thinking of, but that's what the term is, a warrant from a judge to take that person into custody and to bring them to step number 2, which is the second cert, the second exam by a psychiatrist. So sort of two bifurcated options for the first step. And then the second step is that second cert, the exam by a psychiatrist. So the language we're going to look at in this first section, when I pull it up, 7505, is going to deal with the warrant piece. So this is the person who's being observed. It's seeming clear that that person might be a person who needs to come into custody for that second certification, and the process and the transportation for bringing that person to a safe place, a hospital, for that second cert, that second exam.
And that's helpful. Thank you. Can you also just explain a little bit more about what you mean in the care and custody of the Commissioner?
Sure. There is a further process by which a person, there's an application for involuntary treatment. So that's a sort of a court process, an application that the Department of Mental Health fills out. A court would look at that, and it's to determine if the person needs hospital level care, perhaps involuntarily. They don't want to seek that care for themselves. So a court would have a hearing and make a ruling on that application for involuntary treatment. And if the court finds the person, yes, is a person in need of involuntary treatment, then that person would be in the care and custody of the Commissioner of Mental Health. They could be under an order of hospitalization, meaning that they have to receive care in a hospital setting. The other option is an order of non-hospitalization. It's sort of like what it sounds. They are not receiving hospital level care. This individual could be out in the community if they're on an order of non-hospitalization, but they might be required to maybe interact with a care provider or take medications on a regular basis. A person who's at the secure residential recovery facility, for example, they are on an order of non-hospitalization. So there's kind of a big variety of options that are available for an order of hospitalization. But whether a person is on an OH, order of hospitalization, or ONH, order of non-hospitalization, they're still in the custody of the Commissioner of Mental Health. Does that help?
That's helpful to me. Just want to make sure for the folks who may not have heard that terminology before helps. Go ahead, Art.
I just want to understand. So these people have done something wrong if they didn't leave?
No, these are not necessarily, people coming in through the civil door. So I should take a step back even further.
Okay.
So there is an avenue for individuals who are involved in the criminal justice system to come into the mental health system.
Okay.
But there's also a civil door. These people haven't.
Just feel like they have a problem or?
Well, maybe it's an observation that somebody is observing that the person, seems to be a person who's in need of mental health treatment, but they're not necessarily involved in the criminal justice system at all. They're
Okay.
just somebody who has been observed or a physician has found is potentially a person in need of treatment and who
So a
needs
physician can
hospital.
refer them there.
Yes, I mean, that is a possibility.
Okay.
If there's
Involved in that, I guess.
yeah.
Okay, thank you.
Yeah, and I think, so that it'll become more clear as we start taking more testimony.
I think what we're looking at today is sort of a narrow little piece of this bigger puzzle. We're looking at this piece where there isn't a physician available to look at the person, but it's still been observed that this person is probably a person in need of treatment. And so that person is, a judge issues a warrant so that the person can be taken into custody and have this second certification, the second exam done.
Transported and taken in to have that done, but is it determined whether they're under the care and custody yet, or is that part of that second process? They're being
That's
determined?
part of
That's not
this-
the warrant. Or is it?
Yeah, so that's part of the second process. So we'll see in the language that the language talks about, let's see, the law enforcement may take the person into temporary custody.
Temporary, okay.
Yeah, and so after the person's in temporary custody, they're going to have that second certification process where the psychiatrist examines the person. And if the psychiatrist examines the person, says, yes, this is a person in need of treatment, there's a 72-hour window. And during that time, either the person has to voluntarily be admitted for treatment, or the commissioner has to file an application for involuntary treatment to have that person involuntarily treated. And at that point, if the court says, yes, this person is a person in need of treatment, then they're in the custody of the commissioner.
And they could do the second cert and the psychiatrist could say, actually, no, doesn't need to be taken into care.
And then the person would be returned to the community. Yeah.
Okay, I'm confused easily. I'd like to go from step one.
Yeah.
First of all, who determines, can a family member, a physician, who determines this person needs help? Okay, and then the process from there goes where?
Okay.
So do you want to do this, or do you want to walk through the bill and then,
I'm sort of torn because I have like a presentation that has a timeline that shows all the
Oh,
pieces.
okay.
I didn't think we were getting into that today. I thought we were sticking to this
That's
narrow
fine.
piece.
You were going from here to here and I was getting confused.
Yeah, no, it is complicated. It's a complicated process and it's a complicated area of the law. I could give it depends what your time is like. I could give it a try.
why don't we give a short try?
Okay.
And then know that we can come back to it if you're comfortable with that.
And yeah, that's fine. And I know you have experts in the room, so they are probably the best people to tell you how it works on the ground with regard to, for example, a family member referring somebody. So we're talking about people who are not involved in the criminal justice system. So this is a person who is demonstrating characteristics that give maybe a medical professional or a family member or a police officer concerns that this person maybe needs a higher level of treatment. And perhaps they need to be examined to see if they need that level of care. At that point, there are sort of two initial first steps that can be taken. One first step is an initial examination by a physician to determine if the person is what's called a person in need of treatment. It's a term of art in statute. If there's not a physician available to make that first determination, then a police officer or a mental health professional may seek what's called a warrant from the court, and the court will say, yes, let's bring this person in for the second exam. And so at that point, there's a second certification. The second certification, regardless if somebody was initially seen by the physician or is coming in because of the warrant, at that point, the psychiatrist is going to conduct an assessment of the person and determine, yes, this person is meeting the statutory level of a person in need of treatment, meaning they're going to harm themselves or others, or at risk of harming themselves or others. And the psychiatrist might say, yes, we need to hold this person, or no, this person doesn't meet that criteria, and we'll return them to the community. If the psychiatrist says, yes, we need to hold this person, there's a 72-hour period in which either the person voluntarily decides that they need treatment at a hospital, or there is an application for involuntary treatment that's filed by the Commissioner of Mental Health. And then sets off a process where there's a hearing before a judge. The commissioner presents evidence as to why they feel the person meets the statutory level of need of care. And the court either says, yes, you can hold this person under an order of hospitalization or an order of non-hospitalization, or no, this person has to be returned to the community. Did that help?
It does.
Okay,
Honestly.
I have sort of like a flow chart that shows the process, so I will bring that when
That's great.
we dive into this topic again.
That'd be great. Leslie, and then we're going to do the walkthrough.
Mine's real quick. The physician or psychiatrist you're referring to, can that be by telehealth?
Ooh,
Okay,
I don't
not
know
that
the
easy.
answer
Okay,
off the
so-
top of my head.
I just wonder about that process.
Yeah, I'm not sure off the top of my head. Okay,
Great.
I am going to pull up the language.
Great.
Okay. Okay. Do you have it? We have it. Okay. So as I was mentioning, this first section that we're looking at is 7505. And you'll see right off the bat in the heading, this is the warrant piece. So the physician wasn't available to do that first exam. And so instead we're looking at, can a judge give permission to bring that person in for the second exam? I'll read through the first paragraph just to give you a flavor of what we're talking about, but for all intents and purposes, these are kind of conforming technical changes in this first paragraph. So in emergency circumstances where certification by a licensed physician is not available without serious and unreasonable delay, and when personal observation of the conduct of the person constitutes reasonable grounds to believe that the person is a person in need of treatment, the person presents an immediate risk of injury to self or others if not restrained, a law enforcement officer or mental health professional may make an application not accompanied by a physician's certificate to any superior judge for a warrant for an emergency exam. So this is just saying, no physician available, you can apply for this warrant. So the changes we're talking about begin in subsection B. So right now, I'll walk you through this, but right now, you'll see that a law enforcement officer or a mental health professional can take a person into temporary custody. This language changes that and says basically that a mental health professional is not taking a person into temporary custody, and they're only transporting a person if it's clinically appropriate to do so. So the law enforcement officer may take the person into temporary custody. We're striking through or mental health professional on line 15. The law enforcement officer or a mental health professional, if clinically appropriate, may transport the person to a hospital, police barracks, or another safe location in accordance with section 7511. So that's the next section we're going to look at. The law enforcement officer or mental health professional shall apply to the court without delay for the warrant while the person is in temporary custody. One thing I think you'll be hearing from the next witnesses is concern over the cross-reference to in accordance with 7511, which is transport language that was added in the Senate, and instead duplicating that language in 7511 in this section, so it appears in both places instead of cross-referencing. over a concern that 7511 has to do with people already in a custody, commissioner's custody. So that's something, that's where that change potentially would be. Then we have subsection C. Again, I'll read through it, but we're not making substantive changes here. If the judge is satisfied that a physician's certificate is not available without serious and unreasonable delay, and that probable cause exists to believe that the person is in need of an emergency examination, the judge may order the person to submit to an evaluation by a licensed physician for that purpose. Subsection D. If necessary, the court may order the law enforcement officer to transport the person in accordance with 7511 of this title to a hospital for an evaluation by a licensed physician to determine if the person should be certified for an emergency exam. So again, we have this cross-reference to 7511, and I think what you'll hear is duplicating language in 7511 instead of cross-referencing it. Okay. And now that I'm walking you through this language, I'm recognizing that there is a physician exam between the warrant and the psychiatrist exam. Okay, and then in subsection E, again, we have changes adding license before physicians, but I'll walk you through this. A person transported pursuant to subsection D of this section shall be evaluated as soon as possible after the arrival at the hospital. If after evaluation, the licensed physician determines that the person is a person in need of treatment, the licensed physician. It's okay. Let's see. If after the evaluation, the licensed physician determines that the person is a person in need of treatment, the licensed physician shall issue an initial certificate that sets forth the facts and circumstances constituting the need for an emergency examination and showing that the person is a person in need of treatment. Once the licensed physician has issued the initial certificate, the person shall be held for an emergency exam.
Turn the video up here, and then you can also.
Yeah, there we go.
Zoom comedy.
Oh, goodness.
Okay.
All right.
Okay. Zoom is wonderful and tricky at the same time. So once the licensed physician has issued the initial certificate, the person is held for the emergency exam in accordance with another statutory section. And if the licensed physician does not certify that the person is a person in need of treatment, the physician immediately discharges the person or causes the person to be returned to the place from which the person was taken or to such place as the person reasonably directs. So that is the process for the warrant. And again, there's a lot of language here, but you'll notice the proposed change has to do with who can take the person into temporary custody and how to transport that person.
So can I ask a question? So temporary custody, someone hearing that might think criminal proceeding custody, right? But that's not what we're talking
We're not
about.
talking about criminal custody. Yeah, no. And I mean, when we talk about custody of the Commissioner of Mental Health, that's not criminal. That's the care of that particular person.
Okay, Alan?
It also said a safe place. That could be a jail cell.
I will let the experts
Okay.
Testify to that.
Where
Okay.
that place is.
Yeah. All right.
This is all involuntary, or?
This is involuntary.
Involuntary.
After a person has their emergency exam,
All
as I
right.
said, they do have that opportunity to voluntarily go into a hospital. But at this point, this is sort of an observation that the person needs care
Right.
and they're being taken in for the correct assessments to determine if they do
For
need
the
care.
good of the public, say.
Or for themselves.
Yeah, all right.
Mhm. Okay, so next we have a section on transportation. So the commissioner shall ensure that all reasonable and appropriate measures consistent with public safety are made to transport or escort a person subject to this chapter to and from any emergency department or inpatient setting. Then we're removing language, including escorts, then a designated hospital or the Vermont State Hospital or successor in interest, because we don't have a Vermont State Hospital. So by talking about an emergency department or inpatient setting, we're covering Vermont State psychiatric care hospital, which would be the successor in interest. So this is a person under the jurisdiction of the commissioner in any manner that prevents physical and psychological trauma, respects the privacy of the individual, and represents the least restrictive means necessary for the safety of the patient. So we have no changes in B or C. I'll go through them just so you have the full context. So the commissioner shall have the authority to designate the professionals or law enforcement officers who may authorize the method of transport of patients under the commissioner's care and custody. When a professional or law enforcement officer designated pursuant to the previous subsection decides an individual is in need of secure transport with mechanical restraints, the reasons for such determination shall be documented in writing. And then we have a change in subsection D. It is the policy of the state of Vermont that mechanical restraints are not routinely used on persons subject to this chapter unless circumstances dictate that such methods are necessary. That's existing law. A law enforcement vehicle shall have soft restraints available for use as a first option, and mechanical restraints shall not be used as a substitute for soft restraints if the soft restraints are otherwise deemed adequate for safety. So this is basically saying that if a law enforcement officer is transporting somebody, the vehicle has to have the option for soft restraints, and that soft restraints are the first choice used unless there's a safety reason not to use them.
Can you describe what soft restraints are and then what mechanical restraints are?
So soft restraints, Senate Health and Welfare had the sheriff come in and give a demonstration of how they're used, but they look like almost seatbelt material, and that they wrap around the person's waist, and then there's a place for their wrists to hold their wrists down, and I believe it's similar for the feet. So that would be soft restraints. And then mechanical restraints would be more like metal handcuffs, something that's not soft.
Any other questions for Katie?
I don't know if I have a question or a comment. I'm just always amazed at how detailed we have to be to drive someone from one place to the next. It just seems like, a lot. Hey, driving from here to there, it doesn't seem like it should be this complicated. That's just a comment.
I think maybe we can let some of the others decide to answer that question if they want to, and they.
Yeah, get it in, let's go.
I mean, I think, we have to protect people's
I guess so.
care rights, and we have to care for them in the appropriate way. Any other questions for Katie for now? Great, thank you, Katie.
Welcome.
All right, Dylan, do you want to start? Okay.
Sure, we were actually gonna just do it as a team. Myself,
Perfect.
Kristen
Yeah.
and Kristen Briggs. who's,
Great.
doing this.
Okay, so Kristen, if you want to, there's another chair there, if you want to come sit up. And hi, Kristen Briggs.
You got Kristen Square and Dylan.
Yeah, that's easy.
Nice picture, Dylan.
Thank you.
Are you sharing anything on a screen or, okay,
Yes.
I'm gonna give you a second to do that. Maybe while you're setting that up, Dylan, the Kristen Squares can introduce themselves and who they're with.
Sure. Is it easier to start with the screen that I can't see? But
We can't see it now either, so let's start with you.
all right. Good afternoon. I'm Kristen Chandler. I'm the coordinator of Team 2, which is a statewide training for police, mental health workers, and other first responders. And I came in Mental Health Awareness Week and gave you a little overview of that. I also teach at Norwich, and I was in the Attorney General's office with the Department of Mental Health for 8 years.
Seems like a long time ago that you were in here.
I know, but I'm
Oh, that I was in here?
Yeah.
Right, that was the end of January.
Right,
That was just this session.
right,
A whole different season ago.
Oh, wow.
right.
Feels like a million years ago.
Couple weeks ago, I know. And Kristen Briggs.
Yeah, hi everyone. I'm Kristen Briggs. I'm the Program Director of Access and Acute Care at the Clara Martin Center. So one of the designated agencies in Vermont.
Great. And where is Clara Martin located?
We're located and mostly cover Orange County, but we have also additional towns that we cover services for as well.
Great. Thank you very much. And Dylan.
I'm Dylan Burns. I'm Mental Health Services Director of Vermont Care Partners, representing the designated agencies. And I just want to note, Kristen was able to join us right at 2. So some of the questions that I heard you ask around how things work in the field, Kristen will be most equipped to answer, but we may have to just repeat them because
She just came on.
She just came on.
Okay.
Well, I think she caught some of it.
Okay, that's fine. We'll do that. So we'll let you roll with it.
Okay, great. Thanks.
Intermediate.
So we just introduced ourselves and covered, oops, so this doesn't,
It's like frozen.
it says that my screen sharing is paused. Is that?
I can stop it if you just.
Okay. Let's try it again.
There it is.
Okay, excellent. So, the hat I'm wearing today certainly is representing the emergency services director, so folks like Kristen at Claire Martin Center and then her counterparts across the state who respond to mental health crises in each of the regions in the state. So this has a map of each designated agency. That's who we're representing today. And that's the slide. So we're here because those emergency services directors came to us as a provider network and said, we're having some challenges in the field with inaccuracies and inconsistencies in the warrant statute language. And we think that there's been a lot of confusion about who's supposed to transport, how you're supposed to transport, and we think the statute could just do some cleaning up. So our goal is to clean up the language. That's how we started this process, just to prevent confusion and kind of expedite the process, really. We're not trying to alter the rights of people as it relates to involuntary treatment, and we're not trying to assign additional expectations to law enforcement or to the Department of Mental Health or the judiciary. Like, our goal is just to make things more efficient and smoother in the field. The current warrant statute was written in 1967 in a different system, as Katie talked about. And now we really have a more decentralized system with the emergency department operating as that site for doing those physician assessments. So again, we don't feel like the current language really reflects current practice. And what that's led to is that situations in the community where warrants haven't been able to be actioned and there have been unnecessary delays for people who do need treatment. And it's also led to some unsafe situations for providers where they're out in the field, maybe in the community with someone and struggling with law enforcement about who's supposed to transport and who's responsible. And there might be a heightened situation, there might be safety risks involved.
Can we just back up just for a
Please,
second? I
yeah.
just want to make it really clear that mental health warrants are really the last resort that anybody wants to have to impose on somebody. And the two people who can write one are qualified mental health professionals, or QMHPs, and law enforcement. And it's really that those folks working together to sort of figure out and assess, like, is this somebody, excuse me, who needs a warrant? And the QMHP is required to go through all the other less restrictive alternatives before getting to this point where they have to write a warrant. It's a really big deal for a QMHP to have to write a warrant. They know it's taking away somebody's liberty for 72 hours, which kind of goes to your point, Representative, that, even though we may just be even walking them to the hospital, it's against their will. They don't want to go. And the warrant is really, we've heard the questions here, and it came up in the Senate in Health and Welfare as well about the name of this, this vessel, right? It's not criminal at all. And they actually had a proposal for renaming it, which is a whole other, session probably.
Right.
But just to be really clear, a mental health warrant is a way to get somebody some help, somebody who doesn't want it, but is clearly in need of it. So I just wanted to make that really clear.
Thank you. Leslie, did you have a quick?
Yeah, I'm just curious, how many warrants do you think the state has a year?
That's another question.
Okay.
You're mirroring. So issuance of warrants really, it varies by county. Some counties, so the whole idea is you don't have a physician who's available. It used to be years ago, Orange County, Claremont Center had a psychiatrist who would come to the patient wherever they were. And so they hardly ever wrote any warrants. That practice has changed quite a bit. So it really depends because those less restrictive ways of getting somebody to the hospital involves asking them if they'll go voluntarily. Is there somewhere else they could go besides a hospital, like to a step-down bed? So it also depends on what counties have those resources. And those aren't available in every county. And so that's where you then see some discrepancies where some counties are almost forced to write more warrants because their only resource available for this kind of treatment is an emergency department.
So do you have a number?
I don't have a number, but we can get that.
I'd be curious about county, just to understand where the resources are missing.
Sure.
Art?
So you're going from one facility to another with the transportation?
No.
Or
This
from the
is
home?
From wherever you're having your crisis.
Wherever they are,
you're
wherever
having
the
your
crisis
yeah.
is.
Business, middle of the road, by a river.
I see,
your
so the
home.
line man. Okay,
Yeah.
so from wherever they are to a facility, that's the transportation we're talking about.
Correct.
Okay, thank you.
Go ahead.
So, Brandy Littlefield from Howard Center recorded a video for us for Senate Health and Welfare because she was out of town, and then because we just came in last minute,
Yes.
I thought we'd use the video again.
Very last minute. I want to recognize that. Thank you all for the very last minute, like 10 o'clock at night. Agreed to do this.
It's great.
You're still working at 10 o'clock at night.
Right. Everyone was.
I'm hoping this audio works, and if not, we will. No. Okay. Should I? I'll unmute my audio. Maybe that'll.
Okay.
Littlefield, I'm the Assistant Director for First Call for Chittenden County, and I also oversee the Community Outreach Team here for Howard Center. For those who are not familiar with First Call for Chittenden County, we are the crisis team that serves all individuals across the age spectrum, regardless of diagnosis. So we want to make it really clear up front that this legislation is about making the laws clearer and up to date with what current practices are actually looking like. We're serving individuals who may be vulnerable due to their symptoms of their mental health diagnosis. We serve a far greater number of individuals overall that these statutes do not or will never pertain to that we're speaking of today. However, as it is our responsibility to keep our community and neighbors safe, there's a very small percentage of individuals that require greater measures due to safety risks. The laws that we are discussing today are only for those where it's determined that the person is in need of treatment, is involuntary, and they pose an immediate risk of harm to themselves or others in their community. Again, I want to reiterate that this is a very small percentage of our overall client work that is done within our communities. And when it happens, the situation is acute and it requires swift action to keep everyone safe. The changes that we're proposing are about reinforcing most trauma-informed practices so that least restrictive methods are used. For example, soft restraint versus mechanical restraints where possible. It's also about keeping everyone safe and not delaying necessary care and access to hospital care as a result of confusion of who will provide the emergency transport. And if I also could take another moment just to explain what the process looks like slightly for any of you who may not be familiar. Our current process for individuals being seen in the community is that a warrant cannot be obtained unless a licensed physician is not available without serious or unreasonable delay. If a licensed physician is available, then per statute, we're required to complete an emergency examination in the field that would allow for transport of the individual to a hospital or the care facility. If a licensed physician is not available, then we're able to move to a mental health warrant in the hopes of serving individuals who are experiencing vulnerabilities due to their mental illness that is put in either themselves or others in harm's way. And I thought it would be helpful to give a bit of an example of what that has looked like at times on the ground due to the challenges that we are having with the current language that is in the statute. So we had a situation where an individual was deemed to have met criteria for being a danger to others. And this was during the daytime and their psychiatrist was available. We were able to obtain the physician's portion of the emergency examination, which is the EE, to complete the EE process, the first part of the EE process, as we were also able to complete the QMHP portion, which is a qualified mental health professional portion that clinicians are able to do once they have received this credential. Upon delivering the EE to law enforcement, they were unwilling to serve it as they stated that the current documentation of the law did not give them clear authority to transport the individual, and therefore they were unwilling to serve it. As we had a live EE in place following the current law, we were forced to wait for the time to arrive when the psychiatrist was not available in order to write a mental health warrant, so that the law enforcement team felt like they had the necessary legal protections in place in order to transport the individual. Law enforcement was not able to remain with the individual during this process, which left others in risk. And lastly, I just wanted to point out that mental health clinicians are not equipped nor able to take someone into custody to do involuntary transportation. And it has certainly impacted our ability to even have individuals want to come in and join in our forces to serve the population when they are fearful around their own safety and well-being. And I want to end on that there are times that because the law is written in this way that the person in need of help does not get transported or get the help that they need, or that mental health clinicians have felt like in order to get the person help, that they may have to put their own health and safety at risk in order to get that person to where they need to be in order to ensure their safety and well-being. Thank you.
I don't know if people have questions about that portion.
I have a question, and it can be now or later, but so the current statute, I think you said, was in the 1960s or something, obviously, when the hospital was still here. But when did this break? I'm calling it a breakdown, right? In what people think they have a clear authority to do or not. When did that start happening? Or has it always been like this?
I'll say it was happening when I was at the Department of Mental Health, which was 10 years ago.
Okay.
But it's becoming increasingly difficult with the use of force policy. That has impacted the serving of mental health warrants and when police will respond. And it's a separate, but integrated issue. And I don't want to get into a whole thing about that. But so that was October of 21 when that went into effect, October 1st.
Okay. Right.
I know I'm not a witness, but we had a state hospital technically until Irene. So I'm just wondering if perhaps when the actual physical, the former physical campus of the state hospital, when that shut, I'm wondering if that might be when it became more of a problem because but I, as a mental health worker, this has been an issue for the 20-something years that I've been one. That's one of my supervisors, by the way, up on the thing.
Oh, really?
I took her picture and I'm gonna text it to her in a minute and be like, look. So, yeah. But I'm just wondering.
No, that's a great question. I don't remember feeling a correlation there with this particular issue. I think there are other issues around the closing of the state hospital.
Yeah.
But it was really that the law has not been changed for 50 years.
Right.
And the practice has evolved and is different. And I've been teaching law enforcement for 10 years now, and it's like, I always have to tell them, like, here's the law, and here's the practice. And you see this also filter out to judges who, about half of our judges have less than 2 years of experience. So when they are called up in the middle of the night and say, here's a mental health warrant, they go to the law. They go and look in the books, and the books say one thing, yet the practice is different. And it's like, well, this is how we do it.
Right.
But for a judge, it's like, sorry, I'm following the law. And that's another situation where this language hopefully will really clarify that for the judiciary.
Art?
Great context. Thank you.
Yes, on page 1
Of the bill?
of the bill, B, it just describes, it just describes law enforcement officer or mental health professional, clinically appropriate, may transport the person to a hospital. When they say that, this sounds dumb probably, but is the driver someone different? They're back with the person? Or is it them actually driving the vehicle? They are driving the vehicle.
Who's they? When you say they, who are
They
you?
being the law enforcement officer or mental health professional.
Okay.
I didn't know what is, are they a person back with the patient in the back seat or somebody else driving or?
I mean, I think the concern is that a mental health, QMHP, a mental health professional, this language says that they can be the driver and kind of
Person right
have a
next to
person in
them.
the car and that,
In restraints right next to them.
but mental health professionals don't do restraints, aren't trained in restraints in this
Okay.
context.
So
That's where the
only-
statute is.
And you would be driving your own car.
Exactly.
Right.
Okay.
So that's, so this is, you know, someone, and maybe Kristen Briggs could describe, do you mind unsharing? Well, you know what, let's hold on.
We
Let's
don't
let
have to
Dylan,
micromanage.
no, let's let Dylan, no, I think it's good for us to understand. Let's let Dylan go through her presentation. Does that work? And then come back
Yeah.
to Kristen to walk us through kind of how it works in the field.
Yeah, and I just want to explain a little bit about our process and then we can take this down, but we had, Randy and others had brought this concern, so we pulled together a stakeholder group. There's a list of people that we invited and who participated on different levels in that stakeholder group. We met monthly from March to September, looking through this language, talking about it, kind of debating it. We took that group of people and said, invite anyone you want. We'll have an open stakeholder meeting, let's talk about it further. So we had a meeting in the fall in that spirit. And so there's a note here about that, what Kristen mentioned earlier about the term warrant did come up, a lot of agreement around that criminalizes and stigmatizes a situation that's not criminal. We didn't have time to really land on consensus. I don't think there was a lot of disagreement actually about that, but we didn't end up proposing that.
But feel free.
And so then the rest of this PowerPoint just kind of goes through a couple of the points about us supporting the proposed changes. We really want to make sure that it indicates that QMHP's, that only law enforcement can take a person into temporary custody, not a mental health professional. We also worked with Senate Health and Welfare to say there are situations where it might make sense for a mental health professional to do the transport. There were people in our stakeholder group who didn't want to just limit it to law enforcement. So we put in this language that's saying, if it's clinically appropriate, a mental health professional can do it. And that's going to mean the mental health professional thinks that makes sense as well.
And those situations where, those communities where the hospital may be really close to the site, and so they're actually walking people to the hospital. They're not putting anybody in a car, but they're walking them, and we didn't want to just cut that off as a possibility.
I'm sorry, so B versus D, so in B, you're only saying, Katie, still law enforcement, but in D, you're saying either, so maybe this is a question for Katie, what's the difference?
No, the difference is having the judge order the transport, so I think that's the difference, is that we really don't want a judge ordering a QMHP to provide transport.
And that would be B.
That is
D.
Okay.
I think it's D.
And I think that the difference here between B and D is it's about who can take a person into temporary custody. So part of what was happening in the field was law enforcement would say to the mental health professional, you take the person into temporary custody because the language says you can. And we want to clarify here that QMHP's like just the concept of taking someone into temporary custody before you transport, like unrelated to transport, just taking someone into custody.
Okay, I get it. So, okay. I was confused by the language up there. So I'm good now. Thank you. Go ahead,
I'm
Al.
just curious, sometimes you, like you say, walking distance, but up where I'm from, you're an hour and a half away. So is the ambulance services being used in this transportation?
Sometimes.
It can,
It depends on some counties have a much more robust practice of using ambulance.
So it's available?
In some counties, yes.
Okay, in some
Yeah.
counties.
Yeah.
Thank you.
Will you remind me if you're transporting someone and you're a mental health professional, are they technically in your custody? Are you responsible
There's
for
a
them?
liability that attaches, right? I mean, that's one of the concerns.
But are they technically in your custody? No.
It doesn't say that in the law, but I think that anybody looking at it, from an overview would consider that if there was any kind of liability attached.
Do you have any comment on that?
No.
Okay.
Okay, whereas in B, you are clearly saying my interpretation is that mental health professionals may not take a person into temporary custody. So you're saying mental health professionals may transport a person, indeed, but they may not take a person into custody. So you're saying they can transport them, but they are not liable for them during the transport.
Is that what we're saying?
I think, right, just the concept of it would be like asking a teacher to take a kid into temporary.
Yeah, I understand. I'm just trying to make sure I'm following the language.
Yeah.
Okay.
That actually didn't come up in our stakeholder meetings as a concern about the liability piece about that custody. It was really more about, the QMHPs are not equipped to, when we think about temporary custody, the way it's written here for law enforcement, we're talking about hands-on and some kind of restraint, and that's not what QMHPs are trained in or what they want to do. So that's really where it was focused.
All right, we got a couple. So Topper, then Melanie, then Brian.
Thanks for coming in. That question about liability. Unless we put it in here, they're gonna be liable.
Who's there?
The mental health professional.
Well, I'd like to hear what they think about that.
What?
I'd like to know what their take on that is.
I saw a hand go up too.
Yeah, Kristen, do you want to pop in here?
Yeah, I was thinking, I heard what was said earlier about maybe waiting till after this, but I feel like we'll lose the context of this moment. So
yep, definitely.
Thank you. So I want to reiterate what Kristen Chandler said a little bit ago, which transport, we traditionally think about that as a car, but we do walking transport. So there are times where someone might be, yes, they're meeting the criteria for the warrant and involuntary treatment. And then once all of that's happening and they know that they're going somewhere else, if we can get them to go, by foot with us, we're doing that. There's still law enforcement presence. Just because they're not being put into a vehicle doesn't mean that a mental health worker or QMHP is alone with the person, because if something were to go wrong, we still want to make sure that we have that safety aspect from law enforcement. And so the same thing with the transport that got mentioned. If for some reason a mental health professional were putting someone in their car to transport them, I can say personally, we would be asking law enforcement to essentially escort us, or potentially even have somebody join us in our car. And that's where it kind of gets interesting of, is there really a point where that would make sense or be safe to have someone in a car if we're taking that level of precaution? And then the piece, I appreciate what was just mentioned around if someone is not in your custody and you're putting them in your car, aren't you liable for what's happening in the mismatch of language there? I agree that didn't come up, and I appreciate that does seem like a conflict in messaging because there is concern that something could go wrong in transport, and then there's not a trained person in the vehicle to support around that if it's just a civilian, if you will, just somebody who is a mental health professional and not trained in that way. And I would say that we don't consider somebody to be in our custody as QMHPs at any point in this process, and wouldn't feel comfortable with it being put into law that we are ordered. I think we're talking about B and D, that we agreed with the change of not having a judge be able to order that a mental health professional put somebody in their car when they've already decided it's clinically unsafe to do so or clinically inappropriate to do so. And so if we were to put into law, I agree, if we were to put into law with B that we may transport, that that might not make sense because we are then liable. We transport clients all the time who are in our care and treatment and do so always with certain safety precaution measures in place, just like anyone transporting a child or anyone, they care about in a car. And we do that without issue. In these situations, we're saying it's very unsafe and that it would be very unlikely that that would happen. So I do think we'd be uncomfortable as a group, if I can speak for my cohorts here, being liable with somebody in our car that we know may act in an unsafe way that may result in some adverse situation in the vehicle. Is that clear for everyone? Just can't really see all your faces that much.
Yeah, I know, it's hard. I'm looking at Topper to see if he has another question. You got it?
No, that's what I think too.
Yeah. Okay, Daisy, good. All right, Melanie?
And forgive me if you've already, I'm just trying to get all the terms right and understand, and I really appreciate your time and effort to make this clearer. Temporary custody, that's only done by law enforcement, and it's not a duration of time necessarily, it's because they're being restrained in some fashion. Is there any parameters around the time that is the temporary custody piece, or am I getting the definition wrong?
No,
Okay.
right. That's exactly a question that a law enforcement officer asked me last week when we were up in Newport doing a training. It's like, how long is temporary? It's really what's reasonable. It's not supposed to go on forever, that's for sure. And I will say, like in this temporary custody term, law enforcement have the same concern that Kristen Briggs has about liability. So it's not because this, it's not defined in law how doesn't have a set duration, but I think generally it's going to be what is reasonable given the circumstances.
And reasonable getting them to the physician to get the.
Correct.
Yeah, if I could add here that there's events that happen that kind of define the temporary custody is the way that we encourage people to think about it. So once we know that we're starting the warrant process, that's when the temporary custody begins. And then if somebody, so the qualified mental health professional is writing up the emergency examination paperwork, that's their piece. And then they send that along with a short form to a judge for them to read it, decide if they agree that this person meets criteria for a warrant to get them to a physician. So then if they agree and that person meets criteria, they're still in the temporary custody at that point. If the judge doesn't agree, they're no longer in that temporary custody. If the person then goes to, let's just say an emergency department or a setting, a facility where there is that licensed clinician or a physician, and that physician agrees that this person is a person in need of treatment, they're going to complete the first certification for the emergency examination process. And that makes this a complete EE, what we would call a complete emergency examination. And at that moment, the person is then in the custody of the commissioner of the Department of Mental Health. And if the physician were to say they do not agree that the person meets treatment or is a person in need of treatment, then that person would be released, discharged essentially. And we'll get to this later, but then it would be expected that they're returned to where they came from. They're not the ones that need to figure that out for themselves. So at that point, that temporary custody would end if they are either determined not to be a person in need of treatment by the physician, or they are, and it's then transferred to the commissioner.
You good, Melanie?
Yep, thank you.
Brian?
It's hard, like being a worker and not sharing stories about this stuff, but because I've seen like the change in policy and practice over since 2004. So what is that, like how many, 19 years as a part-time crisis clinician, but not a QMHP for the record. I've never gotten that training, but I work with the QMHPs. But I have a question based on that. And any of you can answer it. An EE, from my perspective, is a form of use of force by the state, because it's a point at which a team of people, it's never one person's decision, is making a case after exhausting every and believe me, people exhaust every possible other pathway before it comes to this, and along the way, you keep giving people an opportunity to become voluntary. But in the end, it's use of force by the state due to concerns about safety that are pretty serious. And so earlier, you mentioned that there have been changes in use of force policy lately. between the healthcare system and law enforcement. And I am curious if maybe you could say a little bit more about how use of force policy has changed in the last few years and how these changes in law match the changes in practice, just a little more detail in terms of, like, for example, police. Can I just give an example and then you can maybe launch from there? So, because it's hard to kind of make it just a question. Like, it used to be like there would be a warrant. The police would take the person and bring them to the emergency room, like in handcuffs. That does not happen anymore the way it used to because of changes in use of force policy. It's much more complicated for the mental health providers and law enforcement. But instead of me becoming a witness now and talking about all the changes, I was hoping maybe you could elaborate a little bit about the complications that have emerged because of changes in use of force policy.
I can tell, as it relates to a warrant, and when we talk about use of force policy, I'm talking specifically about Appendix D, which has specifically to do with mental health crisis response, and it's about 8 pages long out of a 32-page use of force policy. And now what is happening is, as far as warrants go, is police will not transport somebody until the warrant is authorized by the judge. In many counties, especially Chittenden County, that has been the practice since October 1st of 2021, which is a big change. Used to be the QMHP and the officer are working together. Hopefully somebody makes a decision like, okay, we have to go for the warrant. And as Kristen said, that's the point where that temporary custody begins, and the officer takes the person and transports them to the emergency department, where they are then met by a QMHP who will then write the warrant. As the language says, if you shall apply immediately without delay, without delay for a warrant. And so there was no issue with anybody having to wait in the field or in a jail cell or a barracks to get help, to get treatment. They were already at the emergency department where they needed to be seen by a doctor anyway. And since the use of force implementation, that Appendix D, officers are now really, in some areas, are really reluctant to transport anybody until the judge has signed that warrant. And I think if Dylan didn't already say this process is not quick. It's a lengthy process, and depending on the time of day and the judge availability, it can take hours, 6-7 hours to, write it up, find a judge, read it to them over the phone. There's some judges require it to be faxed to them. Some judges want you to occasionally meet them in person somewhere. So it's, the whole point of it is to get somebody some help. And there are these delays, our hope is that by this one little insert of a sentence in the statute, it'll be really clear that officers can still take people to the hospital while the warrant is being applied for. They don't have to wait.
Thank you.
Yeah.
Which sentence is, I'm sorry, which sentence is that? Could you help me?
Sure. Well, you know what, I'm looking at an older version, but I'm on line. Yeah.
7505B.
7505B.
So it's on online, it's page 1, starts on row 16.
Oh, okay, that new sentence in there, yeah.
They shall apply to the court without delay while the person is in temporary custody. I think to us that really clarified.
All right.
And will clarify for people actually doing the work in the field, that that's okay.
So I have a question about that, actually. So it says may, it does not say shall.
Mm-hmm.
So a law enforcement officer could still refuse.
Correct. The may part is the temporary custody and transport, and the shall part is if you do that, then you shall apply for the warrant immediately. There's no, okay, now I'm taking you to the hospital, and then suddenly the QMHP says, oh, guess what? They don't actually meet criteria. You're the way this is written, you still need to apply for a warrant.
Where is that?
So in B, subsection B, page 1, we say that the law enforcement may, line 15, take the person into temporary custody.
Okay.
And then we have the second may on line 17, the law enforcement officer mental health professional, if clinically appropriate, may transport the person. But then that last sentence, starting on line 19, the law enforcement officer, mental health professional shall.
Oh, okay. It wasn't underlined, so I was confused about that. Okay.
Okay.
That help?
Thank you for clarifying that.
Daisy, and then Leslie, did you?
I'm good.
Okay, and then back to Brian.
I have two questions that are both, again, related to the timeline. And they're also related to workforce and availability to kind of keep this process flowing to get people quickly to care. Regarding the first evaluation, which is under A, with a licensed physician, would that be with, like in Kristen's case, with Clara Martin, a Clara Martin physician?
With the emergency department.
So actually what we're referring to with the physician is, you know, historically, this wasn't the case. I think Kristen Chandler spoke to the psychiatrists at the designated agencies might need to go out into the community 24/7 to respond to situations. Well, when things changed and the state hospital, you know, became no more, and everyone started being taken essentially to emergency departments to get that immediate care, there's a training that physicians go through that allows them to do first certification paperwork. So they don't have to be a psychiatrist. They just need to be a licensed physician. It could be an NP. And they're approved through DMH to be able to write up that first certification. And then I will just also say that after the first certification and the EE are complete, and it's an EE package at that point, they're in the custody of the Commissioner of Department of Mental Health. There's then within 24 hours of that happening, a second certification that has to happen, and that has to be a psychiatrist. So that's another checks and balance. And then within 72 hours of that, we have the application for involuntary treatment. So the checks and balances along the way that we're talking about, you know, they continue past this process as well.
And that psych eval, does that have to be by the medical director within the DMH?
No.
And it really is.
No. It's oftentimes done through psychiatrists at VPCH, Vermont Care Partners Hospital. And sometimes is done in psychiatry. You know, if somebody is accepted at an inpatient psychiatric setting, then that second certification can be done by a psychiatrist there, but it's common that it's happening while someone's in an emergency department. So it's typically happening with a psychiatrist that works for that medical center, or somebody, you know, working through the Department of Mental Health.
And if anybody, like if you submit a request, Kristen, at any point when a person is is in the custody of the commissioner, does the medical director, the state medical director, does he or she, they review that patient's medical files?
You know, I would not be able to speak to that definitively. But I do know that DMH in general, that they are reviewing these, because if, and they have a legal team, of course, but if at any point there's indication to them that what's written does not meet the criteria that others have agreed did meet criteria, that's another check and balance where they can reach out at any point without waiting for that timeline for the second certification and say, you know what, this is not something that we feel meets the threshold. And so this is no longer in place, you know, and there's a chance for clarity if needed.
So again, finally, just thinking about timeline and any possible hurdles that would slow things down for these folks. When someone does get that order of hospitalization or non-hospitalization, what happens when there isn't a bed available? If the bed board's full, someone actually gets that certificate, where do folks go? I mean, they're sitting there restrained in a safe location.
Sure.
Walk us through a scenario.
So so I'll stick with the warrant scenario, right? If somebody went through that process, law enforcement and the mental health agency collaborated, somebody already said this, we usually are very closely collaborating, planning, making the least restrictive means possible to get them from point A to point B typically being the emergency department setting. They go through the first certification process with that licensed physician. They're now in the custody of the commissioner. and there's not a bed available, there folks who are involuntary typically are meeting criteria for the level 1 beds available around the state. And so they're, I will say often, not always, there's actually bed secured a little bit quicker when someone's at that level, because there's a triaging process that happens with the state. People are waiting across the state. There's looking at the acuity of everyone and the acuity of the receiving entity. So there is by design, an attempt to get these folks to that higher level of care quicker because their need is higher. I will also say that in terms of the restraints, I want to speak to that specifically. The emergency departments, the medical centers, they, by laws that they have to follow, are not able to kind of leave somebody indefinitely restrained, right? So there might be times where somebody is in physical restraints, and those are soft at the hospital, or they may have a chemical restraint, meaning if they were going to be harming themselves or others, and even with the soft restraints were really a significant harm to themselves, they might be chemically restrained, which would be using some kind of medication to help with sedation. And once somebody though is no longer posing that risk to themselves or others, the physical restraints are typically removed. It might be a 4-point restraint, meaning ankles and hands, down to only 2. It might be 2 down to 1, down to none. It's really used temporarily just to keep somebody safe, and then they really have to remove those restraints when they're not deemed necessary under their rules. I'm talking about this from my perspective as a QMHP and a director overseeing folks who do this work. And what I have observed, I want to be clear, I'm not speaking to this because I am, disciplined in the area of the medical health field and extremely familiar with those laws. I'm just saying that's typically what we observe and what we know to be the case.
So much. Leslie and then Brian.
Back to my sort of original question, can the psychiatry evaluation be done by telehealth?
The second certification oftentimes is happening via telehealth.
Thank you.
You're welcome.
So back to the sentence change. It was, what I heard was that the law enforcement, and I might not get the language exactly right, but law enforcement may take a person into custody and transport them to the emergency room before a judge has signed a warrant. However, a warrant shall be applied for. And I guess my question is, like, one of the parts of current practice, at least from my perspective, and others can share as witnesses, is that we are trying to engage a person in treatment at every step of the way. And people often do turn voluntary way down the line before the warrant is secured. But if it says it shall be, does that mean that law enforcement and healthcare are going to have to apply for the warrant, even if the person becomes voluntary at some point along the process?
I don't think so, because at any point we can do we can walk somebody off papers. That's what we call it.
We can still do that even if it says there shall be a warrant.
Yeah, because again, the whole premise is least restrictive method of care. And if somebody at some point says, okay, I'll be voluntary, and just keep in mind that voluntary means that you'll accept treatment.
Exactly.
So it's not like I'll go to the hospital, I'm not taking any of their meds. That's not voluntary. Voluntary is, and that's really, again, where the QMHP is so critical with their expertise to establish and evaluate, can this person really truly be voluntary?
And the other, sorry, Kristen.
Go right ahead.
The other piece about shall apply to the court without delay is, in the language we've got to a hospital, a barracks, or some other safe location. So we're not always talking about a hospital, right? And I do want to say, though, that our interpretation of this also means that just because you brought them to an emergency department doesn't mean you can say, oh, well, a doctor can just do the first certification now and they can do an EE. It's saying that we can't use that as a shortcut to skip the warrant application altogether, that we are still in good faith, we're acting in good faith, that we are going to still apply for that warrant and go through that process. I will say it's also common for this process to happen in the field at a barracks where somebody maybe wasn't safe in the community where they're at enough for this process to happen. So they were brought to a barracks, and this all happens at a barracks, and they're not brought to the ED until the warrant is complete. So I just want to clarify that if they're taken to the ED, we can't then just switch the process. The law says we still need to follow that warrant process because that is why they were transported and taken into temporary custody to begin with.
Yeah, and the only difference there is that now a judge is going to be involved. In the ED process, there's no judge involved. You still have the same medical people, but in a warrant process, you're adding that layer of a judge.
So I know Topper has a question, but I'm going to pop in here if you don't mind, because you've just brought it up. So I'm a bit concerned about the fact that the person may be transported to the police barracks. You know, I've learned being on this committee over the years that may not be appropriate for the situation that the person is in, and it may cause more harm. So I'm curious why that is in here and kind of what led to that being added.
I think so. Again, I'm speaking about this as a QMHP and not a medical professional. The emergency department can be a complicated place to just assume, to bring somebody into, and they're not voluntary at this point. So wherever we bring them, they're not voluntary to go, right? And to have a heavy law enforcement presence in an emergency department with a person in need of treatment who's not willing to engage in any of that at all, and have them be among other people who are seeking care, which may also be psychiatric care or it might be medical care. I think that, we want to be clear that none of us are trying to dictate that is always the best practice to just bring somebody there. And so I think if the person is in a situation where they're not maybe able to be safe, but they're not yet receiving that involuntary treatment because it's a warrant process, then a medical setting kind of sets everyone up to not be able to do what they would do to treat a patient because the person's not their patient until the warrant is secured, right? Otherwise, if they're already at the emergency department and we happen to be evaluating them there without them being brought there by police, the way we just talked about, then that's just a first certification by the physician and an EE written up by the QMHP. That would be different. They're a patient of that emergency department already. So it brings different laws from the different entities involved into play when we introduce someone to a setting where they aren't really yet a patient receiving treatment. And then the other thing that I would add is that it's really common for mental health warrants in the barracks locations to take place because somebody engaged in some kind of activity that was a safety risk to someone else. There may or may not be criminal charges that happen, but there may have been what would be considered criminal activity. And then it was once they were at the barracks, with that process starting, that law enforcement starts to realize or observe that there are signs and symptoms of a potential mental health situation. And so sometimes it's because it was after the fact understood that might be the case that we get called in to consult and provide that evaluation.
Okay.
I want to keep that option open.
Yeah.
And I'll tell you though that in training, I've trained both at the police academy and in the Team 2 training, we train officers to take people to the ED if it's safe. But we also talk about the safest place, and that, as Kristen just said, sometimes it may be a police station.
Well, and the answer made sense. I mean, you think about going to an ED, you think you're going to receive treatment, but if you're not voluntarily there, treatment can't be forced. So that makes sense. Topper, I'm sorry.
Yeah, in this transportation of the person, it talks about respecting their privacy. Can you just talk a little bit about what protocol you use or what procedure you use to do that? Because all of these other things are happening, telehealth, all kinds of stuff. I'm trying to figure out that.
Yeah, this is language that was already in there around, he's talking about in 7511, I believe, 7511D. I'm sorry. A.
One of those. That's the current statute and it's been there for 50 years, but I don't know exactly what the intent behind it was. But the whole idea behind transportation is really designed for those people who are already in the care and custody of the Commissioner of Mental Health, that they have to be transported in the least restrictive method possible. And if that means, and what this particularly means about respecting their privacy, I think it just means you're not gonna, parade them down Main Street. You're gonna remember that this is a medical situation, and there may be some real concerns about somebody for having the public know about what their medical condition is. To not make it. Kristen, did you have something to add?
Yeah, sorry, I think I'm hearing background noise that's drowning something out. Yes, I align with everything you just said, Kristen, and I would add that the law enforcement officer involved in this process for a warrant, and any family members, friends, anyone who happens to be around, they're not held to laws of confidentiality like all of the other people involved in this process are. And so, we also interpret this as the person's privacy should be respected. And, any physician, psychiatrist, QMHP, all of those folks are held to the standard, the law that, that we keep this information confidential and private, and law enforcement is not held to that. They don't have to follow HIPAA. And so I also just think it's a way of honoring, we interpret it as a way of honoring that person's privacy, whether or not your role typically would hold that to be the case. Like, that what Kristen said, that we're doing everything we can to kind of privately address this and not make it known to more people than need to be.
You don't look happy with that.
So what happens if, let's say, an individual, somebody says that an individual, I fear that this person is going to harm themselves or harm somebody else, and they go to that person's house and pick the person up, and they're gonna take them out of there. Let's say it's in relation to a threat at a school. How do you protect that person's privacy? Because I know this is happening, and in the newspaper comes out the name of the person.
Sure.
All
So
that stuff.
yeah, I should be explicitly clear here that we're talking about this process being the mental health warrant process, where it's been determined that it's a person in need of treatment. There's a mental health component present, whereas other situations where there's a criminal component present, but may or may not have a mental health component either present or wasn't part of the process, right? There's a different, that's a separate thing. I can't really speak to how people's names are able to be published in the paper or anything like that, but not all of these situations would involve the mental health component in the field in that moment. That would only be if it's at some point by a QMHP observing that this is a person in need of treatment and calling law enforcement to assist and support in following the warrant process, or if law enforcement is the first responder to a situation and they observe that there's a mental health component and they call in a QMHP to support, and then we go down the warrant process. There's many more examples of times where somebody commits what would be, I guess, recognized as a crime, right, in the community or somewhere, or at a school, for your example, where we might not be involved in any of that process, and there might be criminal charges without potentially a process for the mental health side. And I don't want to speak to that too much because that's not our expertise, but that's the difference for me, is if there was the criminal charges can become, matter of something that can become known to the public, but the mental health component, the process that we're talking about specifically, that's not public knowledge.
Brian, you're next.
Yeah, just on this topic, I was wondering if we might have just a few examples of how law enforcement and healthcare work together to respect people's dignity. Like, for example, I've been in many situations where a person is offered the chance to sit in a wheelchair with a blanket over their hands so people don't see handcuffs. Can you give, because I think it's important to hear this because there's so much care that goes into it. Can you give some examples maybe from the field of how the actors of the state are trying to respect dignity during these difficult transports or these difficult moments in someone's life?
Yeah, absolutely. I can speak to a situation that I was personally directly involved with. I'm not going to give a time frame. It wasn't too long ago, but just given knowledge of, everything we just talked about, I want to keep everything as private as possible. But we had a situation where we responded in concert with law enforcement. It was a mental health warrant situation. It was during the day. So as we discussed earlier, there was somewhat significant delay because judges are in court during the day. And so this happened over the course of several hours. Ultimately, though, when law enforcement were going to the home of the individual with a QMHP with them, the individual was not willing to go with law enforcement. We had a history of this individual. We had gone through a process, multiple processes of involuntary treatment in the past with them. We kind of understood as their treatment team that they were only going to become more of a danger to themselves and others if we did not get this treatment right. So we were able to spend the time that we were waiting, and this is often the case, the time that we were waiting for the judge to plan, if the judge accepts this, if the judge signs off on this mental health warrant, then let's have an ambulance crew on standby. If we can get someone to commit to say that they can be part of this response, let's make sure that the law enforcement has soft restraints available, or that the ambulance would use those. We were able to coordinate and collaborate all of that over the course of the several hours we were waiting. Went to the home, did everything we could in a slow-paced attempt to have the person going into the ambulance with soft restraints. They were not willing to move. Law enforcement safely moved in and used hard restraints for about maybe a couple hundred feet to get them from where they were to where it was safe to have them go on a stretcher in the ambulance. Immediately shifted over to soft restraints, and the person was put into the ambulance and then taken to the nearest ED. So that is a situation where there had been interactions that were unsafe with law enforcement before, interactions with people in the community that were unsafe, and everyone was still able to understand, put that as that knowledge to use in collaborative solutions toward, let's still make sure we're honoring this person's dignity, we're respecting them, and we're using the least restrictive means possible to get them where they need to go.
There's so many examples, really.
That's very helpful.
Yeah.
And there's a way more, I think, from the law enforcement agencies that have an embedded mental health worker, where that person is not in a uniform, and they can really facilitate that transfer of, if they need to be transported to police. And I just want to say, because Kristen just mentioned so many soft restraints, I know there was a question earlier about them. So they, and Katie answered that really well about how they're made up, but soft restraints in an ambulance are totally different. Those are medical soft restraints, which are very easy to get out of. We're talking about in this bill about soft restraints being available to law enforcement they use the same handcuff key that mechanical restraints do. And Lamoille County Sheriff they've been using them for years. And while Sheriff Marcoux did come into Senate Health and Welfare, I think he forgot the restraints or they didn't work. I don't know. There was some issue there. So I don't know that they actually ever got to see them.
Okay.
But they did have some volunteers who were going to be willing to be put into it. But they are generally made out of cloth and they're soft. And some officers are used to using them. A lot of the officers who transport people to court use them a lot, and so they're used to them. Other officers have a different attitude.
I have two questions. My brain is not working. First one was, what happens, so today in practice, there's a situation, you're in a park, let's say, and you feel someone needs assistance and they're not voluntarily saying they agree. And there's the police come and the law enforcement officer says, nope, it's not our responsibility to do a transport. And the QHMP or QMP doesn't feel comfortable either. What happens?
The hope is that they would have a conversation to be able to, hopefully through this collaborative training they've all been doing for the last 10 years, they would communicate well together and be able to civilly figure that out. That the officers really know about the QMHPs aren't gonna call them there or aren't gonna ask them to help them unless they really need them, for safety, because everybody's aware of the short staffing of each other's, agencies and things.
Yeah.
So if an officer really dug their heels in, I think the QMHP would punt, I don't know.
Well, and this is exactly why we're here.
Right.
This is the scenario that brought some of our members to say, can we get this fixed? Because we've
Because of that
gotten these
situation.
situations and then we're in chaos and nobody knows whose role is whose and we're, so.
Okay.
That's fine.
Can you explain how this fixes that, Hans? I mean, really specifically, sorry,
Yes.
but.
Because it specifies that only law enforcement can take a person into temporary custody, and law enforcement a judge can only order law enforcement to transport. A mental health professional can transport if it's clinically indicated, but this says a judge can't order a mental health professional to transport.
So it's clarifying the roles
It's
of
clarifying
who's
the
doing what, when.
Exactly.
Got it.
As well as the timing of it.
Yes.
Thank you for that. Appreciate it.
Okay, so my other question was, you have a list of work group attendees and we will be hearing from many of them next week. Was there consensus amongst all the work group attendees on this language?
Yes, I would say no. I would say we had the 6 meetings, sent out our proposed language and really heard back from no one except for the Hospital Association who is in support. I will say, you'll hear from Jack McCullough and the proposed language that I think he'll bring and that he did bring that up in the work group over the course of the work group. So it's not like people hadn't brought up issues, but in terms of like, do we have consensus? At the end of our process, we just kind of heard silence.
Okay.
So I will just say, I think there are some areas, whether it's either errors or just some tweaks that we can make. We've had, as a group, we had some email dialogue just in the last 24 hours. So what I wanted to say to you is I think before you hear testimony again, we can try to sort through at least some of them and provide clarity from the VCP perspective on our kind of responses to potential other language. We can never predict if someone's going to come in last minute with something, but from what we know, we can respond to what we know about.
Okay, and I believe we're going to have testimony next Wednesday. So just to give you a timeline.
I will just bookmark for you that one of the issues is that the law currently says a mental health warrant can only be written if based on personal observation. And that's not how it works in the field. And it's also not what the Department of Mental Health's warrant form says. They will accept warrants based on a reliable report. And so, just so you're aware, that's a bit of a sticky wicket because it can be unsafe for a QMHP to witness, themselves. They're getting information from law enforcement or from a family member or whatever, and then they're putting that into an affidavit. And Jack has a proposal about requiring, if the writer of the warrant hasn't personally observed it, he would like a separate affidavit signed under penalty of perjury from somebody who did personally observe it.
As part of the warrant process.
Right.
Okay, but that language isn't in this particular section, so we would be looking at another section. Okay, all right, that's helpful. Art?
Katie, what was I don't know if you're even supposed to talk about this, but what was the vote out of the committee in Senate?
I can't tell you off the top of my head. They voted 3 or 4 bills out the same day. It was close.
All right, okay.
We'll find it for you.
Yeah, just good to know.
Any other questions?
We have a comment, listening to all this, up home in Franklin County, the first people get called for anything to do with mental health or this harming themselves or anybody else is our ambulance service. We do not even have a sheriff's department anymore. The state police will only come out of St. Albans, so they're half an hour away. So, and I haven't heard you say too much about the ambulance participation in this. So,
yeah, great. That's so right on point because I just finished up last week a 5-day CIT training here in Washington County. It was a pilot that involves a lot of ambulance, EMTs and firefighters, as well as law enforcement. And EMTs are always invited to Team 2. In fact, I've had several EMTs and firefighters come because they don't get any mental health training. And I'm starting next week, I have a separate contract that UVM got actually District 6 here in Washington County got a grant to train they have 96 brand new EMTs coming out of UVM, and they are getting their first mental health training that this has ever happened. Will be happening over the next 6 months that I'm providing starting next week. That involves a 3-hour sort of overview and then a whole all-day lab where we're going to run through mental health scenarios. So they're starting to get that training. They've been asking for it. They were so thankful last week when we finished up this 40 hours of training, the EMTs in the room anyway, because you're absolutely right. They often are the first people there. And they also have been impacted by the use of force policy where police are not necessarily backing them up. So they've also been asking for some de-escalation training, which is separate.
But in that situation, if this legislation would say that only law enforcement can transport, what does that happen for communities that don't have a local law enforcement agency?
Then they're usually relying on state police or sheriffs. And I'm in the same boat. I'm in Orange County, so we also don't have a sheriff's department. But it's right now it's really hard. It's really hard because of the weight. And it really kind of depends on the situation. You know, despite what we're all reading about in the news that happened here in Vermont this week, the majority of people with mental illness are not violent.
Right.
And then I will get you the numbers on the number of mental health warrants per county.
That'd be great.
But they're really, it's not like a ginormous amount of people who are having to be forced through almost a police process to get to see a doctor, really.
Okay.
I would
Well,
also quickly, if I'm able to just to speaking of the EMTs of the ambulance, and I will also say that we have partnered with them absent of law enforcement at people's homes. If it was a situation where, for whatever reason, law enforcement was not going to go, and we were able to partner with another entity that was willing, then we've done that to go out and see what we can problem solve and how we can get somebody to care the best we can. Just making a system work while waiting to hopefully catch the law up to the system.
Okay. Well, thank you all for your work. Again, I really appreciate the last minute coming in and talking to us. This was very helpful, and will set up us well, to make sure we can continue the testimony quickly. So, yes. Thank you.
So I could just answer Art's question. I just looked it up. It was 500, so we all know.
Great. Thank you. Thanks, Katie. And we can go off live.
Thank you.
Thank